Hello, everyone. This is Tom Fox, and welcome to our first episode of the FCPA Compliance Report for 2025. Today, I'm joined by Jonathan Wilson. I wouldn't say a often guest, but a long-term listener and guest, founder and CEO of the FinCEN Report, and we're going to talk about the incredible machinations we saw in the month of December and literally up to the date of this recording, January 3rd, around the Corporate Transparency Act. Jonathan, first of all, with that incredibly long introduction, welcome back and Happy New Year.
Thank you, Tom, and Happy New Year to you as well.
Jonathan, can you take us through what happened in December of this year, maybe starting with a district court ruling in Texas?
Absolutely. And this was, for court watchers, it doesn't get much more exciting than this. What you had in a case called Texas Top Cop Shop was a business, along with a trade organization, the National Federation of Independent Business, or NFIB. They sued the Treasury Department and the Department of Justice in the Eastern District of Texas, a federal court, seeking to enjoin the enforcement of the Corporate Transparency Act. They had a bunch of constitutional arguments, but their primary argument was based on the Commerce Clause, claiming that the CTA was unconstitutional because it was Congress attempting to regulate a purely intrastate activity, and that was beyond the power of Congress under the Commerce Clause of the Constitution. The district court was persuaded, and they issued an injunction in favor of the plaintiffs. But what made this injunction a little bit unusual is it's what we call a universal injunction. It didn't only say, government, you can't enforce this law against these plaintiffs. It said, government, you can't enforce this law against anybody, anywhere, until this litigation is resolved. In essence, they pulled the brake on the train that was the Corporate Transparency Act, which in early December was heading towards this January 1 filing deadline that we all knew about. As often happens, the government asked the district court for a stay of its own order, which of course the district court denied. The government then went to the Fifth Circuit Court of Appeals. We're going to be appealing this preliminary injunction ruling to you, and we're asking that you would lift the stay, make the injunction go away, while we litigate the appeal with you. Now, the way the Fifth Circuit handles motions like that is the Fifth Circuit actually has 17 different judges that are on the Fifth Circuit Court of Appeals. And they have one panel that hears motions for stay, and then a second panel that hears the preliminary aspects of an actual substantive appeal. The stay panel of the First Circuit granted the government's motion and said, okay, while we hear this appeal, we are going to stay the preliminary injunction. Corporate Transparency Act comes back into effect. That was December 23, a little bit before Christmas Eve. 3 days later, December the 26th, the separate panel of the Fifth Circuit, what's called the merits panel, said, okay, we have jurisdiction of the case now. We're going to vacate the order of the stay panel, effectively reinstating the injunction that was put in place by the district court. So as of December the 26th, the injunction was back in effect. Nobody was obligated to file under the Corporate Transparency Act on the January 1 deadline, and that's where things stood until late at night, New Year's Eve. The government appealed to the United States Supreme Court, asking the Supreme Court to stay the district court's injunction while the appeal at the Fifth Circuit continued onward. And that's where we are today, or at least it was as of this morning when you and I last spoke. It's now the afternoon of Friday, January the 3rd, and just a few hours ago, Justice Alito issued an order telling the plaintiffs in the Texas Top Cop Shop case that they needed to respond to the government's petition by 4 p.m. on January the 10th. So now we are waiting for that filing to take place, and presumably Justice Alito, or perhaps the entire Supreme Court, may take action on the government's petition for a stay at some point after January the 10th.
Wow.
That was a mouthful. Sorry about that.
That was. Before we get into some substantive questions, I want to give you a shout out because in, I believe, December 18, 19, 20, that time frame, you predicted correctly the Fifth Circuit stay panel's ruling. And I think it was on LinkedIn, but it may have been another social media platform. And you were the only person that went on a limb and said that. So I wanted to kudos to you for making that prediction. I thought that was not only a ballsy move, but a correct ballsy move.
I was correct for 3 days, and then I wasn't correct. But the reason for that prediction is actually, I think, going to be important in how the Supreme Court handles the motion for stay.
And what was that?
Sure. So The Supreme Court isn't here to tell us whether they think the CTA is a good law or not. That's not what appellate courts do. Appellate court says, as all the lawyers listening know, rule on very narrow questions of procedure. And just a few months ago, in a case called Labrador versus Poe, the Supreme Court had the opportunity to review a universal injunction issued by a district court in Idaho. That particular district court was ruling on the constitutionality of a state law. The challenge was brought by an individual plaintiff, and that district court said, we're going to enjoin enforcement of this state law against this plaintiff on constitutional grounds, and we're also going to issue an injunction restraining the state from enforcing this law against anyone, anywhere. That order of the Idaho District Court was affirmed by the Ninth District Circuit Court of Appeals, and on appeal to the Supreme Court, in an opinion authored by Justice Gorsuch, said, no, we're going to let the Idaho District Court injunction stand as to the named plaintiff in the case, but we're going to lift the injunction as to everybody else anywhere else. So the law remains in effect for everybody except for the named plaintiff while their particular case is on appeal. That case, Labrador versus Poe, spent several paragraphs explaining why universal injunctions are a bad thing for a number of reasons. Number one, the court argued universal injunctions are problematic because they create issue preclusion issues for the government. Now, the government has already litigated the Corporate Transparency Act in several other cases, and the government has won. By those other district courts, the government should be entitled to enforce the Corporate Transparency Act, but for the order of this one particular district court. Why, the Supreme Court asked, should one district court get to trump all of the other district courts? Instead, they should limit their injunctions to the parties before them. Second, the court's injunctive power is the power of the court in equity. And one of the principal rules of a court in equity is that it should grant no more greater relief than is being requested by the parties in front of it. So if Tom Fox sues the government seeking to have a federal law not enforced against him, if he prevails, the court in equity should issue an injunction preventing the government from enforcing the law against Tom Fox, not against enforcing the law against everybody, everywhere. Third, Justice Gorsuch argued, the practice of having district courts issue universal injunctions, like the one that was involved in Labrador versus Poe, tends to encourage plaintiffs to do forum shopping, to find a favorable district court judge who is willing to blow the whistle and effectively halt the law as to all parties everywhere, effectively keeping the government from enacting new laws while the litigation process unfolds over a period of months or years. So, in Labrador versus Poe, the Supreme Court granted the stay, dissolved the injunction except as to the named party. The facts from a purely procedural point of view in Texas Top Shop are almost exactly identical. That's why I predicted that the stay panel on the Fifth Circuit would do what it did. And in fact, if you look at that opinion, they do cite Labrador versus Poe as to one of the reasons for there not to be an injunction. And it was that rationale that was disregarded by the merits panel of the Fifth Circuit when they vacated the stay panel's ruling. So I think that it will be very tempting for the Supreme Court to issue a fairly narrow ruling, which is we express no opinion as to the constitutionality of the Corporate Transparency Act. Let the Fifth Circuit appeal play out. Let the 11th Circuit appeal play out. Let the appeals of the other cases play out. We'll have a chance to hear it later. But as to the district court's injunction, which enjoined the enforcement of the law for all persons everywhere, that was a universal injunction that we just got done telling you, district court judges, we really don't want to see. So therefore, we're going to lift the injunction as to everybody else and leave it in place only as to the named plaintiffs in the case below. I don't know that I'm willing to predict that's what the Supreme Court will do, but I think it would be very tempting for the judges, now only 6 months after issuing their decision in Labrador versus Poe, to take the opportunity to reinforce that lesson on a case that is, at least procedurally, very similar to that one.
What has been, or what have you seen from the government in terms of their response substantively to this? Have they given us any information, for instance, of the number of corporations who have filed under the CTA, or other information that would lead you to believe that perhaps it's not as onerous as some claim?
Personally, I don't feel that the filing process is all that onerous. I filed for several corporations and LLCs where I'm involved. As the FinCEN Report company does this on a commercial basis for tens of thousands of companies. And even today, with the CTA being enjoined, companies are still voluntarily able to file. And we are filing hundreds of reports every day for companies. It's just not that hard. But in the appeal to the Fifth Circuit Court of Appeals in mid-December, Andrea Gacki had the opportunity to sign a declaration to set out some facts for the Fifth Circuit. And one of the things she told us was that by early December, roughly 10 million companies had filed their initial BOI reports. That's 10 million out of a population of about 32 million or so that the government expected would file. So we were about a third of the way there in early December. There is sort of a hockey stick approach to these filing deadlines. Nobody files their tax returns in February. We all file them in the second week of April. If you graphed it, it would look like that. So it was quite natural to think that there would be tens of millions of reports filed in December if the original January 1 deadline would have stuck. So we don't know how many reports have been filed voluntarily from early December until now, but I suspect it is a number because I know that my company has filed many hundreds of them, and many thousands of them, in fact. So that's what we know. That's the latest from FinCEN as far as the facts go.
Who is Andrea Gaggi?
Oh, my apologies. Andrea Gacki is the director of FinCEN, and she reports to Janet Yellen, the current Secretary of the Treasury.
So from a practical perspective for a corporation, what would you advise today, Jonathan?
You really have two ways to go. One thing you could do is complete your initial BOI report and go ahead and file it. FinCEN will accept your filing. It doesn't hurt you if you do. If you take care of it now, you are able to bypass some of the drama and not have to worry about it. If it turns out that the law is unconstitutional, presumably the government will delete your report one day. If not, who cares? This is all information that comes off the face of your driver's license. The government already has this data anyway. It just doesn't have it in this particular format. The other thing that you could do, you probably should do, is prepare to file your report, collect all the information, figure out who your beneficial owners are, get all of your homework done, and then sit back and wait, monitor LinkedIn or your favorite social media platform, and wait to see what the final answer is. If the final answer is that the CTA is constitutional and all of the Fed filing deadlines come back, there's going to be a pretty short time frame. We're going to have maybe 2 weeks, maybe 3 weeks to file if we get a final green light on the law. And if you don't file voluntarily now, you're going to need to be able to file within that narrow window that comes up if the law does come back into effect by action of a court.
Jonathan, I think everyone, at least on planet Earth, knows we're going to have an administration change on Monday, January 20th. If I ask you to put on your Karnak the Magnificent hat and look down the road, the CTA was a law that was a part of an omnibus bill called the National Defense Authorization Act of 2020. It was vetoed by then President Trump in his first term, overridden by Congress. Technically, the CTA became law via congressional override. I'm not sure I've heard Donald Trump or his putative administration nominees express an opinion on the law. Have you heard anything about which way Trump will order the DOJ or the new DOJ will handle the appeals going forward?
I have not seen any announcements on that. And I think there's an interesting argument to be made as to what the new administration might want to do with the Corporate Transparency Act from an administrative point of view. But it really is an interesting little twist in this case as it relates to this appeal and this particular stay. It has mostly been Republicans from a pro-business point of view who have opposed the CTA on the grounds that it imposes additional regulatory burdens on business. And I get that. I'm a small business lawyer. It's one more form to fill out, and it's kind of a pain in the neck. I get that. And that really was the primary argument that was being made by the Texas Top Cop Shop plaintiffs. However, their argument is that Congress lacks the authority under the Commerce Clause to regulate this purely intrastate activity. If they got everything that they had hoped for, and the Supreme Court backed up the district judges and basically restricted the Commerce Clause so that purely intrastate activities were outside the scope of the Commerce Clause, which, by the way, is an interpretation that courts have been rejecting for the last 100 years. You look at all the cases cited in the DOJ going back to the early 1910s. We all learned these cases in law school. The Commerce Clause is extremely flexible. It covers just about any activity which in the aggregate has an impact on interstate commerce. Let's imagine that the Supreme Court trashes that, dramatically shrinks the Commerce Clause. Now, you're advising President Trump, who wants to enforce federal immigration laws against states and local governments that want to have sanctuary policies that prohibit the local government from cooperating with the federal government as it relates to immigration and the deportation of undocumented immigrants. Do you really want to narrow the Commerce Clause right now? If I was advising the president, I would say, don't take the opportunity to narrow the Commerce Clause. You want it as broad as possible because you're going to want to argue that federal immigration law should trump local sanctuary laws because you need to have the ability to legislate on things affecting interstate commerce, and the presence in a single state of undocumented immigrants impacts interstate commerce. That's one thing. Number two, if I'm advising the president or the new attorney general as to the problem of universal injunctions, I would say, Mr. President, you're getting ready to do a whole bunch of different things, enacting new laws, enforcing laws differently. If you are on record that universal injunctions are a great thing, you're setting yourself up for failure because it only takes one plaintiff to say, I don't like this new Donald Trump policy. Let me go to a favorable jurisdiction, maybe somewhere in Northern California, perhaps, find a judge who is willing to give me an injunction. I can freeze the Trump administration's policy nationwide for months and maybe even years if I just find the right judge willing to issue a universal injunction. A policy against universal injunctions is actually better for the Trump administration because it's going to limit the ability of the president's political opponents to get universal injunctions that are going to hold up the Trump administration's policies. It's an interesting game of push-pull that Republicans are naturally hostile to new regulatory requirements, but in this particular case, the Trump administration might be better served by keeping the CTA in place and by fighting against these universal injunctions at the district court level.
Jonathan, unfortunately, we are near the end of our time for this episode, but before we leave, I wanted to ask you a couple of things. First of all, if our listeners wanted to get in touch with you, what would be best place or manner for them to do so? And second, where can they get more information on the FinCEN report?
The best place to contact me or get information about the FinCEN report is at our website, which is FinCENReport.com, FINCEN report.com. And you can drop me an email at FinCENReport.com, and I would be happy to talk with anyone who wants to talk about these fun topics.
And I'm also going to encourage our listenership, if you haven't done so, connect with Jonathan on LinkedIn. He posts on a fairly regular basis, and it's on this topic. No surprise there. But as I said in December, I thought he had some great insight as to which way the Fifth Circuit initially went. Go ahead and connect with him. I am pretty sure I'm going to ask you to come back on a pod, probably relatively quickly. But even if it's not, we're going to be talking about this in the future. So I wanted to thank you for taking the time over this holiday week to visit with me, Jonathan. Thank you.
Thank you, Todd. We should definitely do that. I would suggest sometime shortly after January the 10th.